Everything you need to know about products and services that can improve your life. This is Experts on Call on CL 650.
We all need somebody to lean on. I just might have a problem that you'll understand. We all need somebody to lean on. If there is a low.
Great choice of a song, Dwayne. It's a great choice, because lean on me is in the whole essence of insurance, right? We have some place to go to when it doesn't work for us, and as Strata Corporation, many Strata corporations access their insurance policies on almost an annual basis in some cases, much to the unhappiness, I'm sure, of their insurance providers. So welcome back. This is QuayPacific's StrataLife, and we have Adrian Murray and Gordon Lee in the studio, and we're talking about insurance and claims. We've worked through some of the kind of interesting technical intricacies of insurance and as it goes through. But let's work through an insurance scenario. A very common one, how it impacts from who pays the bills, how the claim gets filed, how we deal with the different parties. Probably one of the most common, someone is running a bath. They leave the bathtub running, they go out, they forget about it, whatever. The bathtub overflows into the unit downstairs, and there's a claim. What happens? Adrian?
Well, obviously the first thing to do is to stop the water. So and usually what happens, it's the owner below who's seeing water coming through the light fixtures or the ceiling, and contacts somebody in some fashion. We need to get the water stopped. So once we get the water stopped, there's the next call is to the remediation company, and in a managed strata, that'll be the strata manager. And it may even be the strata manager who's calling to turn off the water. In a self-managed strata, it'll be probably a strata council member who's jumping in on the occasion. So once the water's stopped, the remediation company comes in and begins the dry out, and the insurance company's called.
So whose insurance company is going to pay this bill, though? What's the first thing that determines whose insurance company is involved?
Well, most owners, most strata councils will think it's the person who's caused the problem. But that's not how we deal with an insurance claim. What we look at is what was damaged. And so when we look to see what was damaged, and then we look to see who insures it. We've got walls, floors, the ceiling below, perhaps the floor below that, the carpeting. We've had sort of the claim that was the one that established issues regarding deductibles was a overflowing washer that ended up going down three stories. So it'll be walls and floors and joists and all wiring, all those types of things. Those are the things that are covered by a strata corporation's insurance, because they're caught by the definition that I gave you earlier, which was the buildings on a strata plan. Those are walls, floors, and ceilings, and fixtures installed by the developer. So assuming that the cupboards and the flooring and all of that is developer installed, all of that will be covered by the strata corporation's insurance. So notwithstanding that it was the owner's fault or even the owner's negligence that just left the tub running, the first call will be to the strata corporation's insurance company.
So, Gord, the insurance has been called.
So I would get the call, and usually my first question is, what happened? And then the second question, has a restoration company been called?
Right.
The third question, usually, if I look on the policy, which is what is the amount deductible? Now, it's pretty simple. If it's a basic 5,000 deductible, there's a multiple floors or damaged, then I would say no problem. We'll proceed with a claim. We'll get the information, and adjuster will be contact you within usually same day or day after, depending on what time of day you get the call. However, if I do see a big deductible on there, then my question would be, have you asked the restoration company what the possible estimated amount is? Just a rough estimate, because if we have a $200,000 deductible and only 3 units are affected, in that particular case, it may not be a claim that will end up being with the strata insurance. It may be a claim that the unit owner's policy is going to have to pick up under the deductible section, or the unit owner would, I should say, be responsible for that deductible.
So we've introduced a new person in this relationship now called the adjuster.
Yes.
And so the adjuster is, let's assume now that the bathtub overflowed, it's flooded out unit 301, 201, and 101. And you've been called, it's a $5,000 deductible. What is the adjuster's responsibility now?
The first thing the adjuster is going to do is, if a restoration company is there, they would contact the person and then make an appointment to do a walkthrough, take a look what's going on, and then manage that job. And managing means, what needs to be dry, how much equipment gets put in,
Right.
and the time frame it takes. And then look at the time frame and then work with the restoration company or contractor to look at what the repair cost is and sort out who is responsible for what. So as Adrian said, the unit owner, there's some improvements, there's going to be contents that the strata insurance is not going to be responsible for. So that's where you need the adjusters involved, or you need the professionals, because usually the unit owner would have some damage to their own content. So they may already contact their own insurance, have their own adjuster, and their own restoration company, which is different from the stratas who called in the restoration. So once you get that, you have multiple things going on, multiple different people to deal with. It needs to get sorted out who's paying for what and who is responsible for what.
So it's quite conceivable that I could have two adjusters on a job, one for the strata, dealing with strata repairs, and my own insurance policy adjuster dealing with the betterment separate of my strata line.
That would be very common. And then
Right.
depending on whether they have separate restoration companies, or in some cases, if they may have one,
Right.
that will do work for both.
Okay, so the adjuster is really a decision maker in many ways.
Yes.
Right. They're kind of like the unofficial arbitrator of the claim to ensure that the authority is given for the restoration to be done. They provide the report back to the insurance company, who pays for the services
Yes.
and the contracts. But we're left with this deductible of $5,000 now. So the next question, of course, is going to be, who pays for the deductible? And that's not an insurance company responsibility, because as far as the insurance company is concerned, your contract's with the strata is responsible for the deductible. But who ultimately ends up bearing the cost of the deductible, Adrian?
Well, there's a two-step process to a deductible, and I think most stratas need to understand that the Act specifically provides that the insurance deductible is a common expense. So the strata has an obligation to pay the deductible, notwithstanding that we may want to make a claim against somebody else, or we think it's somebody else's fault. Where the strata corporation has made a claim on its insurance, the strata corporation must pay its deductible. Now, once that's done, the Act, and I'm looking at Section 158 of the Act tells us that notwithstanding that it has been a common expense, the strata corporation can sue an owner to recover the deductible if the owner is responsible for the loss that gave rise to the claim. And that language is very specific, and it's been interpreted by the court, again, quite specifically. It doesn't require negligence, and that was determined in the Mari case some years ago, where the owner tried to say, well, my washer overflowed, I didn't know it was broken, so I'm not negligent. And when the court looked at the language in Section 158, the court said, wait a minute, there's no mention of negligence. If the legislature had wanted us to assume that an owner had to be negligent, they would have said that. In this case, they say the owner who is responsible for the loss that gave rise to the claim. And responsibility for the loss is the person that brought it about, or brought the events to occur.
Right.
So that would be the owner who owned the unit and turned on the water and left the tub overflowing. And in this case then, now, will the owner pay the claim without a lawsuit? That's going to be dependent on the owner. Ultimately, the Act says the owner has to be sued, but the owner may choose that, in recognizing that they were responsible, if the strata writes to them and makes a claim, the owner may pay. The owner may even have insurance that covers deductible where the owner's insurance company pays. That's really not an issue for the strata, whether the owner has insurance or not. The strata makes the claim against the owner looking for the deductible. The owner can choose to pay. If they don't, then my advice to stratas is to initiate legal action to collect the deductible, as a general statement.
Well, then the collection of a deductible will, under the Strata Property Act, will be an item that strata corporations will be able to make an application to the tribunal for. So that will assumably make it easier for strata corporations.
Ultimately, although of course we're still some time away before strata corporations will be able to force an owner into the civil resolution tribunal. It's sort of a topic for another day.
Yes.
But even then, small claims court is easily accessible, and strata council members are perfectly equipped to make their claim in small claims court. I think that the problem that arises is if you have a $5,000 claim and you don't make it, and then your deductible is 10, and then it's 15, and then it's 20, you've created a pattern of not making claims, which may come back to haunt you when you go to court or you go to the civil resolution tribunal to make that claim once it becomes $50,000 or $100,000.
The problems that we plant the seeds for today come back to haunt us tomorrow for a strata corporation, for sure. A quick variation on this. Rather than a bathtub overflowing, a pipe in a wall between two strata lots breaks. Same thing. There is a pipe burst failure. It floods out 3 or 4 units. The water gets turned off. Restoration company gets called. We end up having a phone call with respects to the insurance company. The insurance company sends the broker. So we have the same sequence of events, but the difference now, of course, is who is going to pay the deductible and what the potential is for the recovery of the deductible. And I think that's one of the confusions that we see quite often in buildings, is misunderstanding when claims originate with respect to insurance, who's ultimately responsible for those.
Well, that pipe that's in a wall between 2 strata lots is defined as common property. And so if you go back to Section 1 of the Act, that pipe is common property. It's a common property failure that's resulted in the claim. So if you come back to Section 158, the strata can sue an owner who is responsible for the loss, but there is no owner who's responsible for the loss. So this now then is a deductible that the strata corporation will have to pay, and there's nobody to claim back from. It's a strata corporation expense. And interestingly, the Act contemplates that, because the Act even says that if a strata corporation needs to pay a deductible, it can levy the owners without a 3/4 vote. So it can actually withdraw the funds from the contingency reserve fund or levy the owner, and it doesn't need a 3/4 vote. That's the legislature telling us that this is a mandatory requirement of a strata corporation if they've made an insurance claim.
Well, and we've had that happen because where we have strata corporations who have had multiple claims in a short period of time, their insurance deductibles have reached $100,000, and they simply don't have the money left to pay for another deductible. And when the claim arises and they have another claim and another deductible that's $100,000, the strata corporation is in a situation they have no choice, but they have to levy the owners. So it provides some mechanics to be able to do that.
Well, that's right. It wouldn't make sense to go to the owners to get a 3/4 vote. I mean, it's not optional. And what if the owners voted against it? I mean, it puts the strata corporation in an impossible position. So Section 158(3) simply eliminates that whole issue and allows the strata council to make the levy or withdraw the funds if they're fortunate and have the funds in contingency reserve fund.
Closing words, Gord?
Well, closing words is that, for the strata, make sure you get proper insurance. And as a unit owner, make sure you get proper insurance, because you could be responsible for a lot of money. And if you have the insurance, lean on an insurance company.
And whether you're a homeowner or a homeowner landlord, make sure you have homeowner insurance, because you will be paying the costs. Adrian Murray, Gord Lee, thanks so much for joining us on the show.
Thank you, Tom.
I'm Tony Giaventu, host of QuayPacificStrataLife on 650 Sea Isle. We'll be here right back after these messages.
This is Experts on Call on Sea Isle 650.